Good afternoon. If I may have your attention, my name is Dan Attridge. I have the pleasure of serving as the Dean of the Law School, and it's my great pleasure today to welcome everyone to our lecture, including President Garvey, whose presence I wanted to acknowledge. Today's lecture is part of our Brendan Brown lecture series, which began at our law school back in 1992. Brendan Brown, for those of you who are curious, was the sixth dean of our law school. He was an internationally recognized legal scholar who also played a key role in the administration of the Japanese war crime trials following World War II. The Brown Lecture Series invites outstanding professionals from various fields who have made a contribution to public life to share their perspectives on a wide variety of current topics. On the back page of your program, you will find a listing of speakers who have addressed us as part of the Brown Lecture Series in previous years. Our speaker today is the Honorable Diarmuid O'Scanlan. Since 1986, Judge O'Scanlan has been serving as a judge of the United States Court of Appeals for the Ninth Circuit. He was nominated to the bench by President Ronald Reagan, confirmed by the United States Senate, and sworn in all in a period of less than 7 weeks, a pace that seems so remarkably speedy that it's almost impossible to believe in today's world of chronically delayed judicial appointments. Judge O'Scanlan's chambers are located in Portland, Oregon, but he also sits at several other venues in the Ninth Circuit. He and other judges of the Ninth Circuit hear appeals from cases in the western states, specifically Alaska, Arizona, California, Hawaii, Idaho, Montana, Nevada, Oregon, and Washington, as well as cases from Guam and the Northern Mariana Islands. Judge O'Scanlan received his BA degree from St. John's University in New York, his JD degree from Harvard University, his LLM degree from the University of Virginia Law School, and he's also received several honorary doctoral degrees. Much more information about his biographical background, covering both his public and private sector experience, is available in your program. Judge O'Scanlan will be speaking today on the topic of the Catholic Law School and constitutional self-government. I think you will find this topic of great interest in light of our Catholic identity, as well as the fact that our nation is marking the 227th anniversary of the creation of the U.S. Constitution this week. We're quite fortunate to be able to have Judge Scanlon here with us today to share his expertise and thoughts with us. Please join me in welcoming Judge O'Scanlan.
Thank you very much, Dean Attridge, for that very kind and generous introduction, and for your very kind invitation to deliver the Brendan F. Brown Lecture. It is a great pleasure and even greater honor to be speaking to all of you here at Catholic University of America, Columbus School of Law. My presentation this afternoon coincides with this year's Observance of Constitution Day, as you just heard from your dean. The importance of the United States Constitution, not only as our foundational charter of self-government and ordered liberty, but also as the cornerstone of contemporary American legal education, can hardly be overstated. Yet I would like to use this occasion not simply to extol its many virtues or to plumb the intricacies of its august provisions. Rather, I propose that, given our current setting and company, we instead reflect on the distinct vocation that Catholic law schools have, both to our community of faith and to our country as a whole, namely, to form in character and intellect the next generation of lawyers and to impart in them the wisdom of the Catholic intellectual tradition for application to contemporary questions of law, jurisprudence, and constitutional self-government. In one of his many insightful letters, John Adams famously wrote, "Our Constitution was made only for a moral and religious people." Our pluralist democracy does not require citizens, as some would have it, to check their most deeply held religious convictions at the threshold of the public square. Rather, the enduring principles of right and justice, which our positive constitutional and statutory law suppose, have historically found many eloquent defenders in men who have unambiguously invoked such convictions, from illustrious figures such as John Witherspoon and Abraham Lincoln, to the prophetic clergymen such as Martin Luther King Jr. in the last century's struggle for civil rights. With such inspiring examples in mind, I would humbly submit that the duty of transmitting our constitutional principles, with which responsibility our nation's law schools are especially entrusted, is not something inconsistent with, but on the contrary is enhanced by a distinctive and deep religious faith. America's Catholic law schools, accordingly, have a special vocation in this constitutional pedagogy that they most faithfully discharge by remaining true to their Catholic heritage and identity. The relationship between Catholic schools, religious identity, and their practical educational mission has provoked much discussion in recent years. Pope Benedict XVI, in his 2008 apostolic journey to the United States, addressed this very university about the nature and identity of Catholic education today. His Holiness touched in particular on two central themes. In the first place, he called attention to the communal identity and the ethos of our Catholic institutions. Catholic identity, he cautioned, is not just dependent on statistics, nor can it be equated simply with orthodoxy of course content. Rather, we appraise our schools by their contributions to the Church's primary mission of evangelization. Now, when I use the term evangelization, and as the Pope did, he was not speaking of proselytization, in other words, using the classroom lectern as a pulpit, but of making faith, that is, belief in and commitment to first principles and the gospel, integral to education. This role of faith in education is twofold. Given that God is the transcendent guarantor of the truth he reveals, as he stated, and that truth cannot contradict truth, the truth accessible to unassisted human reason does not conflict with, but rather bulwarks that which Holy Scripture reveals or sacred tradition transmits to us. To divorce faith from education, therefore, is to remove the buttress that supports the truth that education attempts to preserve and to transmit. Furthermore, education unintegrated with faith may engage the intellect, but neglects the will, which leads to a distorted notion of freedom. In contrast to the libertine view, which deems an absence of restraint as itself as a desideratum, authentic freedom does not consist in spurning all rules and responsibilities not chosen by oneself. Instead, freedom, properly understood, is the state wherein our intellect acknowledges and our will conforms to the ultimate ground and standard of choice, namely truth itself. Thus, by promoting an environment that seeks ultimate truth, Catholic education utilizes the freedoms granted to us by the Constitution to explore and to express religious and ethical concerns, developing in students an even more holistic form of freedom that unites will and moral conviction. In the second place, Pope Benedict recognized that by integrating faith and education, Catholic schools contribute to the nation's fundamental aspiration to develop a society truly worthy of the human person's dignity. The Church and her academic institutions help shed light on the foundation of human morality and ethics and remind all groups in society, as he says, that it is not practice that creates truth, but truth that should serve as the basis of practice. These objective and ultimate truths, which the Church through her teaching function and institutions illuminates, are the bases on which public consensus can become attainable and can keep public debate rational, honest, and accountable. Without the essential moral categories of right and wrong, hope for the common good and effective self-government attained through communal dialogue only withers, giving way to cold, pragmatic calculations of utility, which render the person little more than a pawn on some ideological chessboard. Pope Francis recently echoed this sentiment when His Holiness lamented that in a culture where each person wants to be bearer of his or her own subjective truth, it becomes difficult for citizens to devise a common plan which transcends individual gain and personal ambitions. Such an amoral society can hardly be said to respect human dignity. Catholic schools, then, are a crucial defense against such degradation of our system of self-government. Contemporary secular society generally rejects the idea of objective norms, independent of each person's subjective choice, enshrining as the ultimate criterion of judgment nothing but the self and the satisfaction of the individual's immediate wishes. Without such objective standards, without an end for human life, in light of which we may direct our actions, our perspective narrows into a relativistic horizon, and ignoring these greater truths, the goals of education are curtailed, and the ends of self-government become muddled. Instead of providing an education in which students learn not only to pursue and to know the truth, but also to love and to choose the good, most schools, even many Catholic schools these days, focus on technical training, at best disregarding and at worst affirmatively excluding any consideration of fundamental truths or substantive norms. The resulting apathy, when extended beyond the educational context, threatens to unmoor our process of self-governing, separating itself from notions of communal justice and ethics, and reducing it into a mere contest of technical aptitude. Pope Benedict thus emphasized two aspects of schools that offer a uniquely Catholic education. First, faithfully adhering to their Catholic identity, such schools form their pupils in the ultimate basis for all intellectual inquiries and endeavors, that is, truth itself, as well as for all exercises of the free will. Secondly, our Holy Father posited that Catholic schools have a special duty to the larger political community, and not just to us and to our fellow Catholic citizens. By articulating and defending truth, the Church's educational apostolate chastens political projects and ambitions in disregard of fundamental norms and corrects the irresponsible, value-neutral notions of freedom that follow from such disregard. The church's role in education is thus to serve society as a whole and not just the faithful. Of course, Pope Benedict did not sketch this ideal for Catholic education with law schools specifically in mind, but his remarks given right here, I believe, have great relevance for Catholic law schools in particular. The law is inextricably related to society's prevailing norms, its view of right and wrong. That is, what it considers justice. These notions imbue even the driest and most technical of legal curricula. Catholic law schools would do well to reflect seriously on what its stated and implied educational priorities suggest about these deeper issues. As among legal education's more highly esteemed institutions, Catholic law schools have broadly demonstrated a commitment to excellence. But contemporary metrics of quality for law schools, career placement, faculty credentials, and the incoming class's LSAT scores do not even begin to exhaust the standards by which Catholic institutions should assess themselves. Law schools, both Catholic and secular, necessarily focus on imparting a technique to their students, a combination of discrete skills, reading cases, writing briefs, oral advocacy, and a distinctive way of thinking like a lawyer, and looking at the world that we as lawyers can instantly recognize as the marks of a fellow Juris Doctor. But this classical lawyerly training is certainly not the full extent to which the church can and should contribute to the formation of future attorneys. Without a grounding in the deeper principles of justice, of right and wrong, legal education provides its students with a powerful set of tools, but without any clear notion of how they ought to be employed. The ancients had a word for this phenomenon, preserved in our language to this day as a pejorative: sophistry. Ancient Greek sophists offered, in exchange for handsome fees, to teach politically ambitious young men how to make the weaker argument sound the stronger. Without a moral vision, without an objective standard by which to distinguish the just from the unjust, or worthy from unworthy uses of our legal acumen, lawyers risk degenerating into a contemporary class of sophists. Traditionally, lawyers prized vigorous argumentation on both sides of a legal issue as a means to uncover, not to occlude, the truth. But we should not be surprised if today's well-trained and rhetorically gifted attorneys, inattentive to the deeper ethical underpinnings of law, prefer to win arguments at any cost, regardless of the inadvertent violence that their clever advocacy may wreak against the cause of truth. Such an unfounded approach, considering the influential position which lawyers hold in our society, has particularly dangerous consequences when employed by members of our legal profession. Thus, Catholic law schools' special contribution in ensuring that legal training is not divorced from the service of truth plays a powerful role in preserving a social order grounded in ethical concerns. Now, one might respond that in virtually all law schools today, and in the legal profession more generally, there is great emphasis on professional ethics. Certainly, the American Bar Association and state bar examiners require law graduates to understand and to observe rules governing both actual and apparent conflicts of interest. The duties of confidentiality and loyalty to clients, and the obligation to avoid sharp dealing and self-promotion. All of this regulation is necessary and salutary, but by itself is a rather brittle foundation. Limiting the means by which we conduct our profession hardly informs us of the ultimate ends toward which we should direct our practice. A robust Catholic education, deeply imbued in the ecclesial life of faith, as Pope Benedict put it, provides just such a broader framework. Catholic law schools should not, and generally do not, rest content in graduating technically proficient and ethically punctilious junior attorneys. Such schools also aspire to form in their prospective graduates a vision about what greater purpose a life in the law should serve, and the ultimate basis upon which any tolerable earthly approximation of justice must rest. That is not to say that this wider view about law and education cannot, to some degree, be glimpsed in the context of a secular law school. But such a vision for education should be especially amenable to Catholic educational institutions as heirs to a robust intellectual tradition in the natural law and cooperators in the Church's larger mission of evangelization. This aspiration to provide law students with a more comprehensive grounding in the principles of justice and right relates closely to the other principal purpose that well-functioning Catholic schools serve. That is, as Pope Benedict outlined, to serve the whole community beyond the Church by giving a rational account of the fundamental basis for justice, morality, and ethics. Catholic philosophy and theology faculties may execute this function at a more abstract level, but law schools have the potential to fulfill this duty directly. In a society such as ours, saturated with statutes and at sometimes suffocated by regulation at every level of government, the prescription of law necessarily dictates much of our daily conduct. We stop at red lights, we recycle our trash, and we purchase health insurance because it's the law. The positivist view of law, a subcategory of the positivistic mentality that the Holy Father specifically denounced, would locate the ultimate authority for these obligations simply in the will of the sovereign, the pleasure of the president, or the whim of some temporary legislative authority. Of course, litigators must argue about, and subsequently judges must interpret, the positive law as the legislative authority has promulgated it, and not according to any underlying moral principles that they themselves might favor. But this practical respect for the rule of law, itself an important principle of justice, does not mean that we lawyers or that law schools and law professors must be blind to those principles that provide individual laws with their content and the law's prohibition with its morally binding force. The Catholic intellectual tradition in law, in fact, has much to contribute on this particular topic. Against the various versions of positivism that have cropped up throughout history, Catholic thinkers have consistently pointed back to the concept of natural law, that law which, as St. Paul says, is written on our hearts. that is accessible to human reason as such, and which provides an enduring basis for right action. I have spoken and written elsewhere about natural law and its relationship to the American legal regime and the judiciary. No doubt the topic would exhaust many lifetimes' worth of prolific scholarship. But suffice it to say for today's purpose that natural law properly understood is not simply a body of rules and prohibitions. Rather, natural law is a set of principles that derive from a comprehensive view of man's purpose and ultimate destiny. When we divorce our understanding of rules that govern conduct, such as many of our laws, from consideration of ends and purposes, we risk subjecting human life to crude and base, purely utilitarian calculations. As I mentioned earlier, Pope Benedict distinctly warned Catholic educators to avoid this danger, and it is one that especially threatens the study and practice of law. Indeed, the namesake of this lecture, Brendan F. Brown, the great former dean of this law school, identified a similar problem in his day. Among his many notable interests and activities, Dean Brown also tirelessly advocated that Catholic law schools draw on our faith's vast intellectual resources to contribute to and even to direct the academic and public debates about the law. In particular, Dean Brown cautioned Catholic law schools against simply imitating the teaching methods of their secular peer institutions and assuming their same philosophical principles. Dean Brown believed strongly that the Church's intellectual tradition in law, especially natural law, as exquisitely synthesized by St. Thomas Aquinas and his school of thought, should provide the jurisprudential foundation at Catholic law schools. This not only meant that jurisprudence classes would expose students to such philosophies, but that all aspects of the curriculum would reflect those principles that comport closely with a thoroughly Catholic perspective on law. Dean Brown saw in his day the dangerous potential in ideologies such as positivism, which have repudiated all basis for law in society, save economic expediency or the will of politically powerful majorities. Accordingly, he, along with many of his contemporaries, discerned a distinct vocation for the Catholic Legal Academy, not only to educate the students in their charge, but also to affect the wider community. Alexis de Tocqueville, in his Democracy in America, likewise emphasized the importance of the legal academy in the American society at large. He highlighted the influence that citizen lawyers have in shaping public discourse. The spirit of the lawyer, born inside the schools and the courts, he says, spreads little by little beyond their precincts. It, so to speak, infiltrates all society, ultimately shaping the understanding of the people as a whole. In contemporary American society, for example, this legal ascendancy gives rise to the mode of public debate about such critical societal issues as the redefinition of marriage, or the issue of euthanasia. So, given this extraordinary breadth of influence that Tocqueville keenly discerned, it is all the more apparent how significant a role American Catholic law schools have to play, not only in shaping American law, but also and especially in forming the outlook and character of the American people. Recalling the words of John Adams, a moral and religious people being necessary for the American project of constitutional self-government, the importance of Catholic law schools in molding American legal and general culture can hardly be overstated. And may I add that your own university president, John Garvey, who graciously is joining us today, eloquently explained his vision for Catholic education in a 2010 article published in First Things, in which he echoed the thought of Cardinal Newman, writing, and I quote, "The goal of the Catholic University is to unite intellect and virtue, which man's fallen nature has allowed to drift apart. We engage the whole person and point him or her toward knowledge and true happiness. The two lie along the same axis and are best sought in concert." End quote. Your Columbus School of Law mission statement further builds on this understanding, and I quote from its statement. As a law school, it reads, "We strive to discover, preserve, and impart the truth in all its forms, to achieve academic distinction in the Catholic intellectual tradition, and to assure in an institutional manner faithfulness to the university's Christian inspiration." End quote. This is entirely admirable and indeed very much representative of the vision that Pope Benedict laid out right here at Catholic University 6 years ago. All this said, I would like to conclude by sketching out a couple of principles according to which Catholic law schools such as yours might best maintain and reinforce their uniquely Catholic identity and tradition in the face of the dominant secular positivism and perfidious political correctness in today's legal culture. I offer these thoughts not as an academic or an expert in legal education or a spokesman for the institutional church, but as an interested observer, a fellow student of the law, and a member of the Catholic laity. It is important, first, that the ambiance of Catholic law schools be ever infused with the Church's rich natural law tradition. Graduates of Catholic law schools should be uniquely familiar with Thomistic legal thought, such that upon entering the contemporary legal world, they will be able to glimpse modern issues not only as the secular mindset frames them, but also through the lens of that law which is indelibly written upon our hearts. In perpetuating and bolstering this distinctly Catholic perspective, such law schools will further counter the insidious positivistic mentality that Pope Benedict condemned. Further, Catholic law schools, in adhering to this principle, will thereby continue to suffuse American society with enriched public discourse concerned with the good beyond the mere satiation of individual preferences. Finally, this is a message relevant not only to my fellow Catholic lawyers and aspiring lawyers generally. The richness of American culture, especially academic culture, has long depended on active and vibrant communal institutions and on none more than its churches and their schools and their universities. Our constitutional order, in addition, presupposes religious pluralism, but our founders remained conspicuously open to, nay, solicitous of, the insights founded on faith that their fellow citizens brought with them into the public discourse. The Catholic and Apostolic faith, which this fine institution upholds and transmits, has great and distinctive relevance to the field of law generally, even as it exists in our contemporary American landscape. All of you should be eager and proud to share this inheritance with our countrymen, and I anticipate that our fellow Americans of goodwill should welcome the diversity and breadth of vision that our sharing would thus help foster. Thank you, and I will be very happy to take any questions that you may have.
Perhaps President Garvey, since you were quoted. Right of rebuttal, or?
Well, I think we see things a lot alike, but let me ask a question that's probably as hard for you as it is for me. I think the great appeal of liberal political theory is that it begins with an assumption that we can't agree about what's true or good, and leaves it to each person to pursue his or her own good, and makes liberty the principle that we agree on first, giving everybody equal liberty to pursue the good in the direction that they find it, so long as they leave an equal liberty for everybody else. Are you just more sanguine than liberal political theorists are about the possibility of our agreeing on what's good or true or so on? Have we gone too far down the wrong path in supposing that we can't agree?
Well, I can confess to being sanguine, but I certainly can confess to being aspirational. It seems to me that these concepts that I've been discussing are concepts that are generally shared in an institution like this, and it is part of our mission as a whole to feel comfortable sharing these concepts and principles. What is scary to me is the tendency to shut the debate down because one may trip and fall on some sort of a litmus test passage or phrase, or to be seen as generally so far out of step with whatever the particular community is that you no longer can fit there. I think we need to be a little more courageous and just not accept what we see out there, but to feel that we can make a contribution, and hopefully little by little, others, as I mentioned, people of goodwill, will begin to say, hey, that's a different point of view. I hadn't thought about it before. I may or may not agree with it, but at least the dialogue is continuing, and it's not just rubber stamp. You follow the mantra that is so often imposed on the debate. Yes?
I'm a lawyer from Australia. I just happen to be past. I'm a lawyer from Australia.
Australia. Oh, yes,
Happen to
yes.
be past
Hi there,
the
mate.
line. I was wondering whether you might say something about judicial method. In Australia, the dominant approach in our High Court is one of legalism, not literalism, but legalism. And a couple of times your Justice Scalia has arrived in Australia, and I gather he's a fairly controversial judge in the
Well, the Supreme Court of the United States has an attribute which regrettably I don't possess at my level. I'm the next level down. I'm on the Court of Appeals, and then of course there's the district court below us. What they are able to work with is the untrammeled ability to reverse its own precedents and to make it up, as you say. I can think of lots of cases in which the Supreme Court has made it up. But I think when you say that Justice Scalia is controversial here, he certainly is well known, and obviously to some people is controversial, but it must be said that he will be leaving a legacy in the Supreme Court, and therefore at our court level, and as well as the trial courts, as well as all the state courts, that textualism, which was a concept that would hardly even been talked about before he was appointed to the court, is now the dominant approach. It is essentially the legal method that even those purposivists will invoke. It's no longer irrelevant as it might have been some years ago. Now, even those who would like to overcome the text and read into the text something that isn't there are committed in today's environment to at least taking the text and then working with it somehow. And I think that will be the legacy that he will leave on the Supreme Court, and I'm delighted to hear that's the view of the Australian system.
Astute. Not gonna pass.
Uh-oh.
Come on, we gotta have one student question. Want me to call on someone? Well, I guess not. Any other questions?
Okay.
Okay. Well, thank you very much, Judge.
Well, thank you.
Really appreciate your remarks.
We do.